an interesting case, McKenzie against McKenzie, which happened in 1970, introduced a new sort of kind of assistant to the case, to the proceedings. It's so-called McKenzie friend. That's a case where actually it involved some divorce, and one of the parties was unable to fund the litigation. Actually, he was refused legal aid, something like last moment before the hearings. And he dropped a letter or something to Australian qualified barrister who didn't have rights of audience. So he wasn't a UK barrister and couldn't represent officially and technically and whatever this person. So he just participated in the proceedings by providing some, consultancy. Basically, he was taking notes, advice quietly. So this is some sort of point you may keep in mind. So basically, he advised that person in between, breaks in the proceedings and things like that, but didn't submit any formal arguments himself. Unfortunately, the judge asked him to be less involved in the proceedings, and because it was just first precedent, when it happened for the first time. And eventually, Mr. McKenzie lost the case. And then he appealed against, basically on the basis that he was refused the legal advice. And based on his appeal, the court found that there's such a role, again, it should be limited to taking notes and provide this advice quietly, but it actually is another potential participant in the proceedings who can provide this sort of advice to the client. So great.